Call the next case, please.
Stephanie Paige Roper, now Stephanie Paige Bruce versus Wesley Garrett Roper.
Good morning, Your Honors.
Good morning, Ms. Miller.
I'm Carol Miller of the Nashville Bar, and I'm pleased to be before the court today representing Mr. Wesley Roper, the father of the minor child, with initials DWB. And Mr. Roper is with us in the courtroom today. Your Honor, this is the father's appeal from the judgment of the Cheatham County
Do you want to
Chancery
reserve
Court.
time?
Yes, thank you. 3 minutes.
3 minutes.
Thank you so much. This is Mr. Roper's appeal from the judgment of the Cheatham County Chancery Court denying his petition for a modification of his parenting plan, specifically a modification of his parenting time and not custody. Mr. Roper was simply asking for the court to award him additional parenting time because there had been, as he alleged, a material change of circumstances, or actually numerous material changes of circumstances that warranted a change of the parenting schedule, not the custody designation, in the child's best interest. We submit that Mr. Roper did prove that there was a material change of circumstances that did warrant a change of the parenting schedule in this child's best interest. However, the trial court disagreed, and my esteemed opposing counsel, Mr. Smith, disagrees because they believe or argue that this change, that at least one of these changes, which was the fact that Mr. Roper was granted additional time by the mother, Paige Roper, her name is Paige Bruce now, the fact that she was granting additional time was reasonably foreseeable at the time of the entry of the initial parenting plan, because there was a statement in the parenting plan that said additional parenting time can be awarded to this effect. Additional parenting time can be granted to the father at the discretion of the mother. So the entire defense at trial basically rested on that premise and seemed to ignore all of the other changes in circumstances that could have also supported a modification of the parenting schedule. So the first thing I wanted to address was this issue of whether or not any of these material changes in circumstances were foreseeable and whether that matters. So let me go, whether it matters that they were foreseeable. My position is no, because Armbruster cleared that up in 2013. I know the court's familiar with Armbruster versus Armbruster. It was a Supreme Court decision that specifically stated that the custody statute that was enacted in 2004, I believe, and they cited the 2010 version, that it abrogated, and basically all the prior decisions that had made any reference to reasonable foreseeability, anticipated change in circumstances versus unanticipated change in circumstances. The mother cites in her brief the case of Price v. Carter as standing for the proposition that the change in circumstances must have not been foreseeable in order for it to be material and to warrant a change in the parenting plan. However, Price v. Carter is a case where the father, in that case, asked for a change of custody. He asked for a change of the designation of the primary residential parent status. This is not that case. Mr. Roper was granted 29 days of parenting time. He agreed to it. I would not have let him do that, but he did that. And fortunately, there were provisions made for changes of circumstances. And some of those changes of circumstances were getting more suitable housing, which he did. Yes, that was in the parenting plan, but he did get more suitable housing. He also married a woman with whom he was having an affair during this marriage, and they are still married today. And she is also here too, Ms. Paige Roper. Those are two of many material changes of circumstances we allege. And also there was a change of circumstances regarding the parenting schedule. Yes, the parenting plan states that the mother may allow additional time at her discretion, but that doesn't take away Mr. Roper's right to actually request a modification so he doesn't have to depend on the mercy or whim of his ex-wife in time. That doesn't take away this. And also, the armbrister made it abundantly clear that whether or not a material change was foreseeable at the time of the entry of that parenting plan is not an issue anymore. It can be for a foreseeable change as long as the parent is not requesting a designation change of primary residential parent, and as long as that circumstance is material and warrants a change of the parenting schedule in the child's best interest. And we would submit that the overwhelming proof was that there were numerous changes of circumstances, some of which were also changes of circumstances that the Supreme Court noted in the facts of the armbrister case, such as remarriage, which is not always a material change of circumstances, but the fact of the perhaps a change of the home environment and other factors that come with having a blended family, a stepmom, and her influence, whether it's good or bad, that could constitute a material change of circumstances, and we submit that's one of the many. And another interesting fact in this case was that really all of the alleged material circumstances were undisputed. It was just disputed that, okay, there were changes of circumstances. They were undisputed. However, I guess it was disputed that they were material because they were foreseeable. And that's really the premise upon which the judge ruled against Mr. Roper. He wasn't asking for a lot. He was asking, instead of the Friday to Sunday that the mother was already granting him an additional day every other week, he was asking for Friday until Monday morning to take his child to school every other week. He was asking for the same schedule to be in effect during the summer, with the exception of 3 weeks of parenting time. He's not asking for a lot. He didn't contract away in the parenting plan his ability to come before a court and ask for a modification, as is his right under Tennessee law. And a parenting plan is not a contract. Because it involves not cattle or chattel, it involves a child. And this court and the trial courts always have jurisdiction to modify a parenting plan if the petitioner proves by preponderance of the evidence that the modification is in the best interest of the child, and indeed that there was a material change in circumstances. Just to run through some of the changes of circumstances real briefly, I'll try to abbreviate them. It was undisputed that the father is remarried and that the mother no longer has concerns about Mr. Roper's wife's drug-related felony. That was years ago. There's no longer any concerns. That was the mother's testimony. As a matter of fact, the trial court
found that the mother and the stepmother actually get along quite well.
Exactly, and there was no dispute that that was one of mine. There was also no dispute that the father's current wife, the stepmom, loves the minor child and has a good relationship with him, that her 2 children also get along very well and they have a close relationship with this minor child, that the father now has a safe residence in which to exercise residential time. At the time that he entered into the parenting plan, I believe in 2017, he was staying at a cabin, and he just didn't feel that it was an appropriate place to have his child. And so he was trying to act in the best interest of his child and also appease the mother's concerns to a certain extent. But the mother acknowledged in her testimony that he does now have a safe place to exercise his parenting time. Also, this minor child was 2 years old, just over 2 years old at the time of the entry of that parenting plan from the divorce. He just turned 9 yesterday. And so we're talking 7 years now, about 6 years at the time of trial. He had just turned 8 at the time of trial, which was about a year ago. And that was another change of circumstances that was noted in Armbrister, and those children were only 2 years older than they were at the time of the entry of the final decree. And family law, unfortunately, no case is ever exactly on point. That's what keeps us in business, I think. But I feel like the Armbrister case really does provide a lot of direction to the courts about what really does constitute a material change of circumstances under very similar facts of this case. Just one moment. Do I need to address any other concerns about the issue of the modification? There are a couple of other issues regarding contempt.
We'll leave that up to you.
Okay. I didn't know if you had any questions. Y'all are being very attentive. You usually ask me lots of questions by now, but I'm going to take that as a good sign, not a bad one. So again, these changes were that the father set forth proof of were really undisputed. So it was not real hard for him to prove by a preponderance of the evidence that there had been many changes of circumstances that did affect the child's best interest. The court just never got there because the court stopped at the foreseeable issue, which is not really the proper standard. So we submit that's the manner in which the trial court abused its discretion. She applied the wrong legal standard to the issue of father's request for a modification of the parenting schedule, and as a result reached an erroneous result, denying his request to have one more day of parenting time every other week and 2 additional weeks in the summer. Also alternating holidays. The only holidays he's granted under the parenting plan that's currently in effect are Father's Day, Father's birthday, and from noon to 7 p.m. on Christmas Day. The father was also held in criminal contempt on 2 counts. We don't know how many counts because the court never found it because the mother never proved how many counts of contempt the father was guilty of. She never approved. The first one was regarding medical bills and the father's alleged non-payment of the medical bills. The father admitted that he had not paid medical bills because he did not receive actual bills. The parenting plan requires the mother to provide those to him.
So the appellee makes reference to an email with bills attached?
Yes, Your Honor, and that was made an exhibit at trial, and I referenced that in my brief. I can't make heads or tails of it, and it's not, the mother alleged that it was $670 of arrearage. I don't get that math anywhere on there. The father was only required to pay 1/2 of the medical bills over $75. The mother didn't prove those. She didn't have a spreadsheet. There was no spreadsheet made an exhibit.
If you supply the bill, though, why would a spreadsheet be necessary?
Well, it's the mother's, it's the mother's burden of proof to prove by preponderance of the evidence, because this was civil contempt, that the father violated the order. She didn't prove what amount he owed. She needed to prove the amount that he owed, and she didn't prove that she necessarily sent him the bills. I think she may have sent him EOBs. I think the email may have contained some bills, and but she didn't. You just really can look at the bills and you can't tell exactly what he owes. And so I would submit that he couldn't be held in contempt on account that, on any counts regarding the medical bills, because she didn't prove how much he owed by preponderance of the evidence. She just said he owes around $670. By the way, I quit sending him medical bills after a while. She admitted that too. So my time's up. I'll leave. Thank you.
All right, thank you. We'll hear from you on rebuttal. Good morning again, Mr. Smith.
Good morning, Your Honors. I apologize for the earlier interruption. I was afraid
No.
she may cough up a lung. So.
No, you were gracious to provide water to her.
Unless specifically directed, I will focus solely on the issues that have been presented and rely on my brief for the others. Your Honor, the difference between Armbruster and the case today, and ironically, the whole parenting plan that I'm sure at points the court sees as a plague that comes in waves, I'm responsible for. I was the attorney that won the Hopkins v. Hopkins case that eventually became the Tennessee parenting plan. And with that, the Armbruster, which eventually cleared it up, because as the court's aware, it's a fill-in-the-blank type deal. and jumping to one of the contempt issues of, they say the heading said only if mandatory, if agreed. Well, the form leaves blanks, and then if you agree to it, you fill in the blanks.
So how did the issue, the lack of life insurance, come up? Was that part of the motion for civil contempt?
Yes, sir. And the court basically lumped in both counts to one single. In an answer and counter complaint that was put in there, there was no response to the counter complaint. And under 803, 804, basically if you don't respond, it's considered that you've admitted it. But it came in on an answer and counter complaint. But the point was also, why argue we need to take this out, which the proposed parenting plan specifically did. It said let's put 0 for the amount as opposed to 50,000, and argued we shouldn't have this if it wasn't there to begin with. But the contempt portions for both sides, my client testified, I gave him a bunch of bills. He was supposed to pay half, never paid anything. Eventually, I stopped paying. The extreme examples of where even if he didn't have...
You said stop paying. She said
Stop
she
sending.
Stop sending.
Stopped sending because he wasn't paying anything.
Yeah.
So it didn't matter what half of it was, half of 0, 0, and he was paying 0. And the extreme case, he had the child broke his arm. He didn't take the child to the emergency room. Mom had to take the child to the emergency room. And he didn't even ask about that bill. Never got a health insurance card. But the testimony and what the court did using the bill that was Exhibit 11, there was a doctor's bill, a dentist bill that said $1,340 is I think what the number was. And then she said in an email, attached is the bill, your half is $670. Although it's argued that that's real hard to come up with that number, I took the number on piece of paper 3, divided it in 2, and ended up finding it was the same number as Exhibit 2's page 2. That's where that came from. And the court focused, as you will look in the findings, she didn't go off in left field looking for all these other bills. She said, this is the bill that was presented. He didn't pay it. That will be the contempt.
Was he to pay half of the medical bills or half of the uncovered medical bills?
Uncovered, but the letter that was sent said, here's what you need to pay. Yeah, they had submitted this stuff to insurance, but that was what was left over, and she had paid her half and said, this is your half. Now, as to the custody visitation issue, I think that the Armbruster case is being a little bit misconstrued. Armbruster, when it focused on foreseeable, there was a period of time to where attorneys on both sides, myself included, would take a look at a decree and say, well, that was foreseeable because if you do A plus B plus C, you're going to get D. And Armbruster said, no, you can't just facsimile everything out as this is a logical conclusion. I think the Armbruster case more was saying the court has discretion to reopen. It's not limited, it's not handcuffed by the potential foreseeability. This particular case is different. This case, a short pencil is better than a long memory. In this particular case, it's not a let's line everything out and see if you should have been able to foresee. The classic example, which does apply in this case, is children get older. The worst thing you could have wish on a parent is that their 2-year-old, their 5-year-old, their 9-year-old never makes 18. So it is foreseeable that children will get older, and we all pray they do. That is not a stretch of logic. But in this particular case, In the agreement, which we disagree with opposing counsel that a parenting plan and a marital dissolution agreement is not a contract, the court sees cases all the time to where enforcing the marital agreement. Well, in this particular case, it was specifically written out upon showing that there's a safe place in mother's discretion, she can grant extra time. Court found she did that. It specifically said upon being comfortable with the paramour stepmom, she could increase that. She did that. But it's not one of those where you were presuming. It was specifically black and white put out. And the interesting thing that you need to look at when you're looking at the sufficiency of what the court was looking at, 8 times on the record, the court specifically found that dad was not credible. The other thing that's important, just like today, at that court, stepmom was listed on the witness list. When asked about it, dad said she's electing not to testify. She's not going to take the witness stand. The point is, a lot of the stuff that those credibility issues on, income amounts, where he fluctuated anywhere from $17,008.50 to $71,000 and about $35, and the court was like, either you're not telling me the truth, which is what I'm finding, or you've never looked. He was the foreman of a company. He's saying, I don't know how much I make. I don't know.
Well, what about, though, the other side of the coin? They're saying that even if you ignore father's change of income, just keep it the same, there's still a significant variance by the mere fact that mother is making more now.
Your Honor, I think actually what dad's testimony was is I don't know what mom's making, and
But your brief cites to what she's making, so
Yes,
we
sir.
know that came out in the proof.
yes, sir.
So there is that element of it. So, I mean,
But
why wouldn't that be enough if we put pen to paper, short pencil, as you say, to a child support worksheet, and it shows that with her income, even assuming father's income remains what it was, there's a significant variance.
Well,
Why wouldn't that be error for us not to change the child support?
okay, there's a couple of reasons. One, the court found that she couldn't do half of the equation. She couldn't figure out what dad's income was because dad testified, I don't know what it is, even though he was the foreman of a company. And
Well, I'm saying, though, you imputed as to what it was originally, when he was still at Piedmont Gas.
so the 71,000.
Right, 71,000.
Also, you would need to factor in, and this is where you get back to the issue number one, that the foreseeability, the second, and ironically, both mom and stepmom have the same first name. So the current Miss Bruce, that's why I'm saying stepmom, she was already pregnant at the time the divorce was going through. They specifically made deviations for that new
Well,
coming
I'm
child.
saying you could still do it. You could work out just don't deviate on the new worksheet.
Yes, sir, that could be done. And if the court chooses to do that, that's within the court's power, obviously. But the point is, the court found that dad's credibility to be gracious was lacking, and she said that multiple times in findings. And with that, the person that could have answered those questions was sitting in the courtroom, and even on cross-examination of dad, well, if mom's not here, if stepmom's not here yet when she gets here, the court want to hear from her, and he's like, she's not going to take the witness stand. The issue that we have is a he said, she said, and under the presumptive missing witness rule, the one person who could have answered would not take the stand, which one can presume would work against the side who controlled her.
But irrespective of father's credibility, there's no factual dispute here that he has married since the divorce.
Correct.
And that his home now is suitable since the divorce.
Yes, sir.
So that's
But
Those
that
are
was also,
established, and there's no factual dispute that the child has grown older.
no, sir.
Okay.
And
Which
all of
are
those,
three material changes that the Armbruster Court specifically singled out as, hey, this is something that would meet the very low, as the court said, the very low threshold for establishing a material change of circumstances.
yes, sir, that's what it says. The difference being they specifically addressed this unlike the normal scenario. And the court acknowledged this is an unusual factor because a year before Armbruster, specific things that were addressed in Armbruster as a theoretical, they had specifically said, if this comes up, we will do this. If this comes up, which is different from Armbruster. And that, we believe, the court found no material change because it was not I think they were talking about this, they specifically set out, here's the rules, if this rule changes, they get married, stepmom cleans up her act, they have a home, then mother shall do this. That's the short pencil, that's the huge difference, and that is the distinction that I believe.
Yeah, so, I mean, basically, as I gather, your argument is that you can craft a permanent parenting plan that is in fact always going to be permanent, because if you anticipate in the plan itself potential changes, you could never seek a modification.
No, sir, I am saying that using his Honor's scenario of the child getting older, it may clear up the question until age 12. But yes, sir, I believe using contract law, if you specify out enough detail, and yes, frankly, I was surprised. I wasn't the trial attorney, but I was surprised when I read this marital dissolution, just how detailed they were on if A, then B, if B, then C. And yes, I do believe that you can craft that much detail that would eliminate some of the options that Armbruster says in the general sense, please apply. Yes, sir, I do believe you can craft that. I do think that you've got one heck of an attorney if they do that, especially not knowing it, but that's what happened in this case. I'll be happy to address any other questions the court may have.
Hearing none, Mr. Smith, thank you.
Thank you, Honors.
Ms. Miller?
Thank you. I'd like to touch on the issue regarding child support. Mr. Roper's income at the time of the entry of the final decree was actually $90,000, just over $90,000. It was $7,581.14 per month was what was put in the child support worksheet. The mother's income at the time of the entry of the final decree was $2,667 and change. At the time of the trial on the petition for modification, the mother's income was $5,400 and some change. And the father was not a great witness on his income. In reviewing the transcript, that was easy to see, and the court did find him not to be credible on.
And he had the burden when he was looking to change child support.
Yes, Your Honor, and he did. But what he had the burden of was to prove that there had been a significant variance in the child support that was between the child support that was ordered and the child support that he would be ordered to pay under the current circumstances. So what we submit is then what we've argued in our brief is that it was incumbent upon the court, rather than just dismiss this case after Mr. Roper had specifically proven through through the mother's, I keep wanting to call her Ms. Roper, but through the mother's testimony, she no longer had $975 per month of child care. That's significant credit she was receiving that she was no longer entitled to. She was also, her health insurance credit had changed significantly. It should have been about half of what it was. He wasn't asking necessarily for all that to be retro, or he may have been in that, but it was incumbent upon the court to, if the court was not going to accept Mr. Roper's proof about his income or lack thereof, all she had to do was impute the income, and that's what she implicitly did. She basically found that, look, you don't know what your income is, but
So was the trial judge requested to do that below?
I don't believe specifically.
I mean, because it seems to me there's an element of fairness here. We're playing, well, the court could have done this, but, you know, you need to give the trial judge an opportunity to go that route. You say, look, Judge, if you don't believe my client, you can believe Mother here in her testimony, and if that wasn't offered, I don't know how we can fault the court below for not going that route.
Well, I understand that, but look, talking about fairness, is it fair for Mr. Rober to continue to pay child support that's based on, I know, this is rhetorical.
Yeah, I'm not answering. Well, let's leave that for just a second, because I want to talk or ask you about one other element of the contempt here, which was on the life insurance policy. Your brief made some points about, well, the language of the agreement says if the parties agree or something to that effect. And I thought, okay, I can understand that argument. But then when I saw, hey, this was off the form, I appreciated why that language in here. It looks like to me the parties did in fact agree to the life insurance. It's just that language left over from the form did not get deleted.
Yes, Your Honor. Just one moment. I have a note about that on my computer that I forgot to bring up. Thank you. At E, and I have found that the state's forms, I mean, I know they're well-intended and they work the majority of the time, but I have found that my office deletes this language so that there is no question about it. So the first problem is, right after the words life insurance, it says
It's
not mandatory.
Not mandatory, which is on the form.
Right, it says not mandatory. And then it says, if agreed upon by the parties, the father shall insure her own life in the minimum amount of $50,000. We're talking about contempt here. That's the problem. If we were talking about, okay, look, dude, you know, you've got a good faith agreement here, but we're talking about contempt, and there has to be, as Your Honors know, a valid and enforceable order. Now, when you
let me just sum it up. Yes or no? Is it the father's position that he was confused about the obligation to get life insurance?
No.
Okay.
All right, Ms. Miller, I think your time is up.
Thank you, Your Honor.
All right. Thank you, Ms. Miller and Mr. Smith, for your arguments. We'll take this matter under advisement. That concludes the morning docket.